Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
Hi, I'm Gina.
And I'm Sam.
And welcome to Sam the Answer Man podcast. Sam, I got a question for you. So I have a friend who received this letter who said, from this big highfalutin law firm, and it said that, you're using our trademark and you need to pay us for the use of that.
Yeah, those are fairly common. There are a lot of firms and a lot of companies that like to send out letters trying to bully people into not using the identification they use for their businesses because they claim that they violate trademark. And a lot of times the claims are not true, and they're really just trying to force people into either paying money or abandoning their marks.
So can we back up a little bit? So what exactly, let the business owners out there know, what exactly is a trademark and why do you need to protect it or not violate it, someone else's?
So trademark can be either words or pictures or both that are intended to describe a business, and they're protected both by federal statutes and by state law. And basically what they say is that under the right circumstances, if one business is using a certain word or identification, a phrase as their trademark or a certain picture, other people can't use it, and they can get sued if they try to do that.
Okay, so do you consider them trolls? These people who claim they have trademarks that they may or may not have?
Well, a lot of times they do it unjustifiably, and they're just trying to sort of force a settlement or force somebody to pay some money or force people to abandon their marks, because there's only certain circumstances under which a trademark is protectable. Just because somebody says something is part of their trademark doesn't mean that it's protected under the law.
Kind of like an Ipsy Dixit trademark?
Right. In other words, I can claim that my business is protected by the word, law firm, and say anybody who uses the word law firm has to pay me money or is prohibited from doing that. I can't claim law firm as a trademark because it's too common. The trademark law recognizes sort of four categories of trademarks and sort of ranked in order of how protectable they are. And the most protectable is what they call arbitrary and fanciful. So that's a kind of a fun word.
Arbitrary and fanciful.
It's actually good to be arbitrary and fanciful.
Sounds like something a dandy boy or dandy girl would say.
If something is completely sort of random, then it's most protected under the law. For example, if I call my business Fuzzbinit, Fuzzbinit's not a real word.
Easy for you to say.
It's not used in the language. And so that would be something that would be called arbitrary and fanciful, and therefore I really would be able to protect my exclusive use of that word. However, there are other categories sort of lower down from that. Another is suggestive. In other words, something might be suggestive of the product, but not exactly describe it. For example, I know you drive a Mercury Mountaineer, right? So Mountaineer, as applied to a car, kind of describes the intent of the car as to let you go up into the mountains, that kind of thing, but it's only suggestive. And so that can be a protected mark. Then there's another one that's called descriptive, which more exactly, car that goes fast. If I was to try to trademark that would be a lot more difficult because that is very descriptive of the product involved. And in those circumstances, descriptive marks are only protected if they acquire secondary meaning. So there are certain marks out there, like Jell-O, where
Kleenex, Band-Aid.
They're very descriptive of what they do, but they're so used that they've acquired secondary meaning in the market, so they are protected. And the last is generic, and that's just sort of like a English word from the language. Like car, I can't trademark my car as the car because car is a generic word. And a lot of times when people get these letters, what the writers are trying to bully them into accepting is that a very common English word is protected as their trademark, and it probably is not. It's a very good idea to have those reviewed by an attorney to see if there really is a good trademark claim there or not.
So what are the advantages of registering a trademark? I mean, why should our viewers care?
So a trademark can be protected even if it's not registered. And a lot of times when people get these letters, the trademark involved is not registered. I've actually had clients who had a registered trademark get a letter from somebody who had a non-registered trademark trying to claim that their registered trademark violated their non-registered trademark. Non-registered trademarks can be protected, but your remedies are less. If you register a trademark, first of all, your trademark is rebuttably presumed to be, we had that word in another podcast.
It's fun to say.
rebuttably presumed to be valid. Another is you can get attorney's fees and additional damages if the trademark is registered. Another issue is that if I have a trademark for my business, I've not registered it, it's probably only going to be enforceable locally. I can enforce if the other circumstances are such that I can enforce it. I can enforce it as to other competitors or other businesses in my area, but in another state, somebody would still be able to use the same trademark. So registering is not necessary, but there are advantages to registering.
Can I trademark something that makes a product work better, or
No,
enhances?
well, not really. So I've actually seen clients get letters from people who claim, "Hey, you're using this design for this product, and it's ours because this is something we do to make our product work better." That actually is not an argument for protection for trademark. It's actually an argument against protection in trademark. Patent law covers inventions. Patent law covers ways of making a product or ways of doing business that are functional. But if you don't have a patent, you can't use trademark law to say, I'm the only one who can have an orange hunting vest because orange is so colorful that it protects a person from getting shot by somebody else. That causes it not to be protected. It's called functionality. If something is functional, it cannot be used as a trademark. So if something actually makes the product work better, that's something that indicates that it's not protected by trademark rather than it is.
So all of this falls under what they call intellectual property, right?
Correct.
So trademark and intellectual property is?
It's anything that protects, ideas. And trademark is one example. Copyright is another, and patent is another. These are all fields of intellectual property law. But trademark specifically covers, words or phrases that are used to identify products and services.
And so that's a great definition for trademark. And then you talked about patents protecting inventions,
right?
Things like that. Copyrights protect
artistic works.
So like songs,
right?
Lyrics,
songs, books,
works of art,
right.
That kind of thing. So back to trademark. Have there been any recent cases or any cases that are significant regarding trademark?
Yeah, there actually was an interesting case last year in the U.S. Supreme Court. It was Metall versus Tam. And in that case, a band made up of Asian Americans had the name the Slants, and they wanted to trademark.
It's an interesting name.
Well, that was the trademark office had a problem with it. They wanted to trademark that name. The trademark office said, no, you can't trademark a name that's disparaging, and the word slants is disparaging to Asians.
It is, but how is that not a First Amendment violation?
Well, that's actually what the court said, is that even though you can claim that this word is disparaging, if they want to use that word, they have a First Amendment right to use it, because the First Amendment doesn't stop protecting people even though the thing is disparaging. And so that they actually prevailed in arguing to the court that even though it's quote unquote disparaging, they had a First Amendment right to have that trademark registered. A lot of people during that case, myself included, kind of thought that that case was being backed by the owners of the Washington Redskins, because the Washington Redskins had a similar problem. The trademark office had terminated their trademark as to the word Washington Redskins. And for a while there, anybody could say they were the Washington Redskins, because the trademark office said that Redskins was disparaging to Native Americans and therefore was not protected by patent. But after the Metall versus Tam case, the courts in the Washington Redskins case came back and said, based upon that precedent, Washington Redskins is protectable as well.
Wow. So why didn't the Redskins just pursue theirs to the Supreme Court?
Our theory is that
cut the middleman
the
out.
guys in the Asian band who are actually Asian and wanted to use that word sort of presented a more attractive litigant than the Washington Redskins, which was a big
who may or may
football
not
firm,
have been.
most of whom probably were not Native Americans. So sometimes the status of the litigant, although it shouldn't matter for the constitutional principle, sometimes it might. And so I think that they sort of put forward this case with a more attractive litigant in order to establish the principle.
Wow. So there you have it. So what should people do if they have questions about patents, trademarks, or copyrights?
If you have a mark that is important to you and you want to protect it, you should probably talk to an attorney about whether it's protectable, whether it makes good sense to register it. If you get a letter from somebody claiming that you're violating their trademark, do not just immediately buckle under. Certainly investigate, have an attorney look at that and give you an opinion as to whether these people are just trying to bully you or whether you do have a serious problem in violating somebody else's trademark.
All right. So look for us. Sam has written a great article on this topic. You look on our website, recent post, and there'll be a great article on there about trademarks. You can find us online at ventolalaw.com. You can also find us on YouTube. Yay! Subscribe to our YouTube channel. For our audio friends, we are all over the place when it comes to audio, such as Stitcher and iTunes and Facebook and Twitter and Instagram. You guys get to see some of these clips that we put together on Instagram. So wherever you want to be, we will be there.
Just search for Sam the Answer Man.
It's all Sam the Answer Man. So you guys have a great week, and we'll talk to you soon.
Bye-bye.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.